Good morning. Tashi, yes, good morning. You can drop me a text and I will call you back. And no, there is no fixed time, Mayank. And Vipul, the class will be uploaded day after tomorrow, from what I understand. Okay. Now we are going to do a means specific topic today with a little bit of relevance as far as the pre is concerned. This is the third topic in the mains, which is called separation of powers between various organs, dispute redressal mechanisms and institutions. See, when we look at this topic, we must understand it's a very simple concept. The parliament is supposed to make laws. The legislature is supposed to make laws. The executive is supposed to implement those laws. And the judiciary is supposed to question the existence of those laws, question the validity of those laws. When these three organs of government start to do each other's jobs, when these three organs of government start encroaching upon each other's territory, that's when the notion of separation of powers is invoked. And if you see the kind of questions that the UPSC asks with the application of separation of powers, you will understand that they ask it from an analytical, from an overview kind of a view. So let me run you through those. And then we'll start with separation of powers. So if you see the kind of questions that have been asked, first, resorting to ordinances, and we've already covered ordinances. Resorting to ordinances has always raised concerns on the violation of separation of power, while noting the rationale justifying the power to promulgate, analyze whether the decision of the Supreme Court on the issue may have further facilitated to the resorting of this power, should the ordinance power be removed or maybe repealed. We've covered this before, because what happens with ordinances is, an ordinance is basically a law directly brought in by the president on advice of the elected executive, which is the Council of Ministers, right? Now, apart from this, if you see the other two kind of questions that have been asked, one was, of course, on the Arbitration Conciliation Act, wherein you're setting up an alternate dispute resolution system, wherein you're looking at solving or settling disputes beyond the courts. Okay? And then, of course, there was the IR Coelho case, wherein the court is reviewing the judgments and sometimes giving pronouncements which may transgress the boundary of separation of powers. Now, apart from this, if you see the more recent kind of questions that have been asked, you'll be able to understand why this is a separation of powers issue. Okay? Now, let us see. Sumit will have to give me one day for it. First is the tribunals issue. See, primarily, tribunals are a midpoint of the judiciary and the executive, because tribunals, while are courts, comprise of members of both the judiciary and the executive. Okay? Tribunals, while are courts, but the judges of the tribunals are proper judges, judicial members, and sometimes members of the permanent executive, which is the bureaucracy. So how do tribunals affect the jurisdiction of the court? The validity of it and the competency of tribunals in India. Then you had a larger theoretical question, which is, do you think the principle of separation of powers is strict or not strict, and is it based on checks and balances? We'd understood this in our earlier classes, that checks and balances is an outcome of the principle of separation of powers. Then there was a dedicated question on tribunals with respect to the Central Administrative Tribunal, because of certain judgments that had come out in 2019, wherein they had essentially transgressed what their primary jurisdiction was. And then in 2020, there was a larger question in terms of, in the garb of a judgment, the job of the judiciary is to review an existing law and can't use the shelter of a judgment to make a law in the form of a court order, right? And therefore judicial legislation and its implications, with respect to separation of powers and its application to public interest litigations. I'll just check. I think the volume is very high. I can see that the input here is quite high, but I will certainly have the backend team look into this. Okay, now let's start. So what is it that we should be focusing on? We should be focusing on the larger concept of separation of powers and checks and balances. We should spend specific time on ordinances and tribunals. And then we should be looking at judicial review and activism, which of course will be given to you, and alternate dispute resolutions and lok adalats. So let's look at some of these explanations and let us see what is it that we're trying to get to. Okay, now let's start. Now, separation of powers is something which you may be asked a general studies question on, and you may also be asked a GS question on. Okay, so let's understand it from a contextual or a historical point of view. So the political philosopher Aristotle, in his book Politics, discussed the concept of separation of powers by stating that every constitution should have a heterogeneous form of government. Heterogeneous means a distinctive form of government, wherein you should largely have three branches. First, the deliberative, which is the one which discusses issues, which is the one that figures out what the solutions should be. Then the public officials who are implementing the discussions and the decisions of the deliberative, and the judiciary who make sure that these decisions are in the best interest of society and the country as a whole. Now, the French philosopher Montesquieu basically gave more structure to the idea of separation of powers. This may be of more interest to the students of political science optional, but even when general studies students quote Montesquieu in their answers, you definitely get one or two brownie points. So Montesquieu had basically described the division of powers as an executive, a legislature, and a judiciary. And this is the structure, this is the division that most countries in the world are actually using this. And when you understand this in a further amount of detail, you get to the point that it was Montesquieu who had actually for the first time given a structured, more comprehensive, a workable model of all of this, of separation of powers, in his book called Esprit de Louis, which is also called Spirit of the Laws, in the year 1748. This is also at the same time, in the same context as that of the Revolution. Now, this basic explanation that he had given was based on the British constitutional system, wherein he understood that the monarch, which is the head of the state of the British government, the parliament and the courts of law had to work separately so that they are not dependent on each other, and they're able to independently, without any external influence, think of what is in the best interest of the country. And he also understood that the basic three functions that should exist of the three branches have to be that the first is that the executive should not exercise any legislative or judicial powers, because by doing so, you would threaten the freedom and the liberty of individuals, which is why liberty as a concept also has some correlation to separation of powers. Obviously, for example, if the executive, the government of today, right, starts making laws, when you make ordinances for that matter, when the government passes an ordinance, now that ordinance could be pervasive in nature, could be restrictive in nature, and unless the parliament has eventually sanctioned that ordinance, the ordinance could be construed as something which infringes upon the rights of individuals. Similarly, if the executive is also performing judicial functions. For example, in fundamental rights, we studied why, upon arrest, do you need to take the person to a judicial magistrate within 24 hours for approval of custody? Is because the executive is implementing the law which is being made by the legislature. Now, if the executive only decides that the person should be kept in jail, now that is a judicial decision. And if the executive was also performing a similar judicial decision, then again, the police would unnecessarily detain people without an unbiased set of eyes for it. Similarly, when the legislature should also be prevented from from exercising executive or judicial powers, and you must understand why, because this could lead to arbitrariness. The legislature is not equipped functionally, technically, and with a degree of expertise to understand the nitty-gritties of the implementation of the law. And when the legislature also tries to exercise judicial powers, like we saw in the case of privileges, we saw that when the legislature was deciding on whether an MP or an MLA has in fact breached a privilege, these decisions were often very political in nature. And we've seen the success of literally a negligible number of MPs or MLAs in the history of this country who have been disqualified, or who have been suspended, or who have been penalized for breaching the very privilege to the very democratic temple which is the parliament that they are a part of. Similarly, the judiciary. Similarly, the judiciary. Now, when we do look at the judiciary, we understand that if the judiciary starts exercising legislative powers, and while this is something that we must understand, in India, the judiciary is often considered to be nothing less than a knight in a shining armor. The judiciary has undoubtedly come to our rescue, has helped us move in the right policy direction, has really helped us move in the right policy direction. But is that the job of the judiciary? I mean, if you think about it, the judiciary today upholds a degree of primacy is largely because of the incompetency of our legislatures. Take the case of Vishakha versus state of Rajasthan. When we do take the case of Vishakha versus state of Rajasthan, what do we understand? That no doubt that the Supreme Court did the right thing by making a set of guidelines which for more than 10 years were the guidelines on sexual harassment law at workplace in India. And it took the parliament more than a decade to actually make a law preventing sexual harassment at work. But at the end of the day, it is a judge, it is a court which is making the law. And the judge is an appointed one. An appointed office is fundamentally making a law. That law is disguised as a Supreme Court judgment that doesn't make it morally right. Okay? And then, of course, the judge could act the way the judge would. Now, the Constitution of India does recognize separation of powers. It understands the division of it, and in fact, under Article 50 of Directive Principles, it is expressly mentioned that that we should try and separate the judiciary from the executive. And this is something which directly affects you, because when you make it to the All India services, more specifically the IAS, and when you are posted in your subdivisions and your districts as SDMs or DMs, what ends up happening is the CRPC and the CPC does give you the power of acting like a judge. In fact, you are a judge. Once a week or once every 15 days, you will actually hold a court wherein small revenue cases, petty civil and criminal cases, they will actually come to you for hearing, and you will be called what is called an executive magistrate. Now, the problem here is you are the one who's implementing a law which is made by your political masters who are the elected executive, and you are basically performing the job of the judiciary. Now, it is a matter of necessity. It is a matter of helplessness that we do not have enough lower judicial officers in the country, which is why these jobs have to be given to the officials which are present at the level of the district, which is why it makes the whole process slightly more cumbersome. It makes the whole process slightly more difficult. Okay, so that is something that we must understand. Now, this is the context of it. This is why we are discussing what is called separation of powers, right? Now, what are separation of powers necessarily supposed to do? See, there are basically 5 objectives of separation of powers. The reason I've given you these 5 objectives is because in the mains, you may get a question theoretical in nature as far as separation of powers is concerned. The first objective of separation of powers is that when you make sure that the legislature, the executive, and the judiciary are as separate from each other as possible, you're able to create a form of accountability that X is your job, and X, if A's job is X and X is not done, then you can hold A accountable for it. You can hold A responsible for it. And this is why it is important for you to have separation of powers. It creates an ecosystem where arbitrariness, totalitarianism, and tyranny could be eliminated from a given country, society, or an administrative unit. 2. It also prevents the misuse of powers within the organs of the government. If the legislature knows that its powers stop at making a law, it will not transgress its mandate. So will not the executive. So will not the judiciary. Now, this would largely apply to the executive and the judiciary, because if the judiciary knows that my job is to review a law that already exists and not innovate it to beyond the point, then in such a scenario, of course, I will keep myself in control. I will keep myself in check, right? And therefore, the Indian Constitution does provide for certain limits and boundaries. For example, in India, the words like judicial activism, judicial review, they're not mentioned in the Constitution. The courts have derived those powers. The courts have sort of advanced applied those powers, of course, to suit the conditions of the country as a matter of necessity. But such is the case. So, the Constitution, no doubt and unquestionably, is the ultimate sovereign beyond the people of the country, and automatically, anything that goes beyond the principles of the Constitution should certainly, be withdrawn, be taken back, right? So that's the second point. The third point is that it keeps a check on all the branches by making them accountable for themselves. Which means that by separation of powers, you can make sure that if the executive is overstepping its boundaries, the legislature will be able to, take an action which further reduces the power of the executive, because the power of lawmaking would largely originate from the legislature. And fourthly, the separation of powers also maintains what is called a degree of power balance, so that there is no one branch which gets too much power. And therefore, if you think a military rule is a problem, so is the judicial rule, so is an executive rule, right? For example, the emergency in India is often criticized to be, executive dominance. We often question judicial activism on the grounds that it is judicial dominance. So any form of dominance across any of the parties will always be a certain amount of an issue, right? And fifthly, this is the principle that allows them to do the best and get the best versions of themselves, right? Which basically makes sure that it allows them to get better at what they do, enhance the quality of lawmaking, enhance the quality of implementation, the quality of judgments, and therefore improve the overall efficiency, of the government. For example, today in the newspaper, I think in the Indian Express, on the front page, a question by an MP, because right now the parliament is in the budget session, and in the morning question hours happen, and you will be able to relate it. There was an MP who was asked a question on why is India rank, which is the 53rd in the democracy index, which is published by the Economic Intelligence Unit, so low, and what are we doing to improve it? That just reflects how a separation of powers could also necessarily get better. Because if you look at the criteria of the of democracy indexes or indices, it's about the utility of the governments, the power structures, the reasonableness of the judiciary, and of course so on and so forth. So this is largely how it works. This is what we are referring to. Okay, excellent. Now let's understand, how does this work in the UK? How does this work in India? And how, in a parliamentary system of government, the concept of absolute separation of powers is flawed. Because in a parliamentary setup, the executive comes from the legislature. So it is impossible to strictly separate the executive from the legislature. Right? Now, when we talk about separation of powers in the UK, we understand that the UK practices what is called unitary or a constitutional parliamentary monarchy, which means there is a centralized government, and at the same time, you have a head of state which is not elected but hereditary in nature. Now, how does this apply? Now, because, and this is what you must understand, for good separation of powers, for you to say legislature can do X, executive can do Y, and judiciary can do Z, there must be a single law which it tells you exactly what your power structures are. But in the UK, you have an unwritten constitution, which means you don't have a single law which you could call the constitution. You have multiple laws which are called constitutional laws, but you don't have a single unwritten constitution. And because you don't have a single unwritten constitution, you don't have a single written constitution, the whole concept of separation of powers becomes very difficult, because power originates from the law. If you don't have a singular law, then this division of power could also become slightly difficult, because constitutional laws are then treated as ordinary laws in the country of UK, which is why it's not purely rigid. And therefore, UK, unlike India, is a parliamentary supremacy, where the parliament can make any changes to any law, and therefore this equality of division of law could be altered by the parliament, since the parliament is the sovereign law-making body. So theoretically, the parliament of the UK can wake up tomorrow and say that, boss, I'd like to give myself more powers than the other branches of government, and that is theoretically possible. Now, the government unquestionably is answerable to the parliament, and therefore what ends up happening is that because you have majority in the lower house, the executive is controlled by the House of Commons. Now, thankfully, the UK does not have an anti-defection law, which means that even if you are a member of the same political party which has the government in the UK, you can still question and vote against the party if you think, the party was not doing a good job. A classic example of this would be the ex-Prime Minister of UK, Theresa May, who was the Prime Minister during one of UK's tougher times where Brexit was being negotiated. And there was a point of time, there was a specific point of time where she had tabled a proposal for Brexit after the referendum to the House of Commons. And the Prime Minister's proposal for Brexit was defeated on the floor of the lower house of the UK, which is a very interesting point to note because MPs of her own party disagreed with her policy proposal to execute Brexit. The opposition thought this was a golden opportunity and pounced to introduce a no confidence motion. But to everybody's surprise, the no confidence motion failed. And that really is the true essence of democracy, that the members of the government party in the UK disagreed with the Prime Minister's policy on Brexit, but at the same time had absolute faith in her leadership quality as the Prime Minister. Now, the last, of course, is that the judiciary of the UK, however, is independent of executive control, but the judges of the Supreme Court can be removed by both the houses. What is very interesting to note is that the Supreme Court of the UK is in fact one of the newest and youngest Supreme Courts of the world. It only came into existence in the year 2011, right? And therefore, what ends up happening because of this is, before 2011, it was the House of Lords of the UK which functioned as actually the Supreme Court. Guys, please don't ask me questions in the middle of the class. I am not your personal tutor. Have the basic decency to conduct yourself properly in class. I will cover all possible domains, then you can ask me your questions. So this is exactly how your separation of powers in the UK sort of works. Now, of course, we have a proper independent system in the UK, but before 2011, the upper house of the UK, the House of Lords of the UK, used to, of course, double up as the Supreme Court of the UK. Now, we will compare this to the US Constitution and see this is how it works. Now, what happens with the US is, we must not forget that US is a presidential form of government. Now, because the US is a presidential form of government, as a result, the head of the state and the head of the government, who is basically the same person, is elected separately. So you are actually able to create a more clear division of separation of powers. So no doubt the US, unlike the UK, has a written constitution and is therefore governed by the presidential form of government. And this separation of powers, in fact, is clearly defined, explicitly written in the American Constitution. In fact, one of the first provisions of the American Constitution, one of the fundamental provisions, are explicitly on separation of powers. You know, it's clearly in black and white written in the American Constitution. Then we must also understand that the president and the ministers are unlike a parliamentary democracy, unlike India, where the prime minister, who's also the head of government, is a member of a house. Any minister that the prime minister wants has to be a member of either of the two houses at the center. But that's not the case in the US. The US follows something called a spoils system, wherein the ministers of the US are basically the presidential staff, the presidential members. The ministers are called secretaries in the US. So, and for example, the defense minister in India is called the Secretary of Defense in the US. The foreign minister in India is called the Secretary of State of the US. Now, what basically means here is that whoever you want to choose as the defense minister in India, you have the freedom to choose who you want to, but that person, at least within 6 months, should be a member of the houses, right? That's not the case in the US. The president can literally pick anyone under the sun that the president wants to be the Secretary of State of the US, because the president himself, at the moment or ever is not a member of the Congress, is not a member of the houses of the US. The president is not a member of the houses of the US. And in India, the prime minister has to be a member of at least of either of the two houses. That is why the ministers are clearly appointed by the president. And therefore, they are only accountable to the president and not the Congress. This has also been under criticism because the ex-president of the US, Donald Trump, was accused of appointing his son-in-law, Jared Kushner, to some key functionary positions in the US government staff. So, of course, there are some good and bad things to it. Now, the presidential tenure has nothing to do with no confidence motion, with parliamentary majority, adjournment motion. None of that applies there. It is independent of the majority of the Congress. Of course, in rare cases, you do have procedures for impeachment of the president of the US. They were very close to doing so for Trump, but that never happened. And as far as lawmaking is concerned, the Congress, or which is basically the parliament of the US, is the sovereign legislative authority. It consists of two houses, the Senate and the House of Representatives. Senate is the upper house and representatives is the lower house, right? And because everybody is completely isolated, you're able to very clearly fixate that this is what you're supposed to do, this is what you're supposed to do, this is what you're supposed to do. And therefore, the impeachment of the president can be done collectively by the houses, and they're essentially called the Congress. Okay, now sometimes the international treaties that are entered by the president have to also be approved by the Senate, and of course the Supreme Court of the US is independent. It is independent to the point that they also have a limited election process, but that's again not something you have to worry about, but they do have a limited election process. Yeah, which is also why when you hear of the nuclear deal that happened between India and the US, the nuclear deal was often called the 123 deal, because section 123 of a law in the US had to be passed to create an exception that India is a country that has not ratified the Non-Proliferation Treaty, the Comprehensive Test Ban Treaty, and is not a member of the Nuclear Suppliers Group. And still, the US is going to provide nuclear technology and other infrastructure in return for a financial cost. So an exception was created, and that nuclear deal had a lot of political consequences in India, where a no confidence motion was also moved in the parliament as the CPI had withdrawn their support from the Congress. But the no confidence motion did not lead to fruition, right? Now, of course, the court, by being independent, can also declare any action of the executive or the legislature as unconstitutional as the need might be, right? So this is how separation of powers works in the US versus how separation of powers works in India. Okay, now let's understand this with a little more context to the judiciary. See, the president of the US does interfere in the functioning of the Congress by exercising, of course, their veto powers. What ends up happening is, for example, in the Obama healthcare, or is it with the case of Trump wanting to build a wall, the president does have certain veto powers over laws of the legislature. And a lot of times the budget is drafted by the president, and the houses can a lot of times block the budget also, right? So of course the president does make appointment to the judges, and also is questioned to have interfering in their judicial powers. Similarly, the Congress also interferes in the powers of the courts by making procedural laws, by making special courts, and by, of course, approving the judges. And the judiciary, by exercising the power of judicial review, also interferes in the powers of the Congress and the president. Now, why have I given you this? I've given you this because you must understand separation of powers is incomplete without checks and balances. This is like a management principle. If you're the CEO of a company and you have say 3-4 departments and you've given them a very specific kind of work to do, and then you'll be able to make sure that A department is keeping a check on B, B is keeping a check on A, and everybody knows exactly what they're supposed to do, right? So this is largely how the concept of checks and balances also originates. Now let's look at it from the point of view of India, and let's understand what did we want to do about this and how far have we reached in this entire discussion on separation of powers. See, first things first, and I'll be very clear on this, the words separation of powers you will not find in the constitution directly. The closest you will get is separation of judiciary from the executive, or the conduct of a judge cannot be discussed on the floor of the parliament. The conduct of an MP cannot be discussed by a judge unless there is a specific disqualification proceedings going on. Otherwise you can't. So you have application based principles or application based provisions of separation of powers, but the term separation of powers as we know it is not mentioned in the constitution at all. Right now, the constituent assemblies assembly debates definitely indicate that separation of powers was never intended. I mean, it was the whole concept of it, whether rigid or whether sort of fluid, it was never supposed to be a part of the governance structure in the country. It's because when they tried to introduce a new article called 40A, where they wanted to mention complete separation of power between the three branches. This was this person called Professor K.T. Shah, who was a member of the Constituent Assembly. This amendment never did go through. The Constituent Assembly did not pass this. And one of the key people who was responsible for this was, of course, Dr. B.R. Ambedkar. And he said, well, see, I understand that bureaucrats should not be judges and judges should not do the work of bureaucrats. I get that. But you must understand that there is a need that the Mantri and the MP are sort of dependent on each other, because one is making the laws and the other is implementing the laws. So I cannot strictly separate them. It would be very difficult, and otherwise there would be further complications in the duties of the government. Okay? And then we further understand, what are the provisions which sort of support separation of powers. You will be using them in your mains answers as and when we get there. Okay, so Articles 53 clause 1 and 154 very clearly mention that the executive powers of the union and the states have been vested in the president and the governor respectively. You don't need to know these for the pre, you need to know the article numbers for the mains. Article 245 says that the central and state lawmaking authority to the parliament and states respectively, therefore empowering the parliament to make laws for the whole country. And it is from here that we will, in our next class onwards, study center-state relations. And then Article 50, of course, categorically refers to separation of powers between the judiciary and the executive under the Indian government structure. So therefore, you will find application-based provisions, but you will not find the word separation of powers as such in its isolation in the text of the Constitution. Now, apart from this, you will also see some other provisions. For example, with respect to autonomy and independence, Articles 122 and 212 basically prevent the courts from inquiring into the proceedings of the parliament and the legislatures, unless, of course, there is a disqualification question in place. 105 and 194, we've discussed this with respect to privileges, have been basically give judicial immunity for anything spoken, or in fact how they even vote during their sessions. And Article 361, the President and the Governor get the immunities that we have discussed in Article 14, where in their professional capacity they have absolute immunity, but in their personal capacity, if it's a civil issue, 2 months notice, and if it's a criminal issue, as long as they are holding office, right? And the Supreme Court and the High Court judges are also immune from a scrutiny of their conduct under Articles 121 and 211. You can't discuss the conduct of a judge unless, of course, you are specifically removing the judge. And I hope you can, just pause for a moment and appreciate what we've basically done is I have taken provisions from everywhere and I've put it in one place. And this is the analysis, this is the correlation, this is the diversity that the mains answers are expected to be. Okay, so we've understood provisions that support separation of powers. Then, of course, there will be certain provisions that don't. So we want to come to that in just a bit. Now, while we've spoken enough of how separation powers is great, we must now also quickly look at how separation of powers could also be compromised, where there is really, not a lot of separation of powers. Okay, so let's understand. First is overlapping personnel. See, you must understand that our ecosystem is such that the Lok Sabha and the Rajya Sabha is the larger subset and larger set, and elected executive is a small set of the Lok Sabha and the Rajya Sabha, which means there is a commonality of personnel. We've discussed this between the organs of the Council of Ministers also being members of the Parliament. They're also exempted from office of profit because this is allowed. You're supposed to be this under Article 75 and as well as the executive under 74. In fact, we've discussed this. The President is a part of the Parliament but is not a member of the Parliament. That is how the President gets to dissolve, gets to prorogue, gets to start a session, gets to call a joint session. The President is able to do all of those things. It also takes decisions on disqualifications, on Representation of People's Act and the core text of the Constitution. So the President is a part of the Parliament, but is not a member of the Parliament. And then there are, of course, I'll give you permutations and combinations. There are overlapping powers between the executive and the legislature. Now that we've understood that they're correlated, there is, of course, some form of overlap, right? So basically, the powers of the executive are coextensive to that of the legislature, which means the Council of Ministers at the center only have those powers on implementing those laws which the Parliament has the powers to make. Then this also applies to ordinances, that the Council of Ministers can draft only those kind of ordinances which the Parliament could have made laws upon. So they are coextensive. And therefore, the executive exercises legislative powers, for example, when we talk about ordinances under Article 123. And similarly, when the President's assent is required for bills which are proposed by the legislature, remember it says the executive authority vests with the President. But when the Parliament has passed a law, it has to be assented by the President, and the President works on the advice of Council of Ministers. So here you can see the legislature and the executive are, colluding with each other to the best interest of this nation. Right? It also means, so presidential assent is required under Article 111. Apart from this, you also have legislative functions of the President, wherein, when you're proclaiming a state emergency. So I'll give you a basic idea. In a national emergency, there is no such thing called a state list. As a union list and a concurrent list. So wherever there is a national emergency in place, the parliament can also make laws on state list in that region where there is a national emergency. So national emergency can be all India, can also be on a bunch of states or a state also. And with state emergency, there is nothing called a concurrent list. Everything becomes a union list. The center then starts making laws for the legislature. That's why it's called presidential rule. And the center means the president starts making laws for the states. Here also there is of course a midpoint. We will do emergencies in detail when we do center-state relations. So don't worry. And apart from this, the very concept of delegated legislation. We discussed delegated legislation. RTE Act, RTE rules. Motor Vehicles Act, Motor Vehicle rules. NGT Act, NGT rules. Rules are drafted by the executive. They don't have to be passed. And because they don't have to be passed, they are able to, be directly enforced. And of course, there is a decency that you have to maintain, that the rules should not violate the overall ethos of the law that we are talking about. So the very concept here happens where the executive is drafting rules on the basis of a law which empowers the executive to do so. And this is done in the context of administrative adjudication or administrative law or administrative ecosystems, right? And so 372, Article 13, both allow for this to happen because rules are also considered law in the context of Article 13, Clause 2. The Council of Ministers, as I've said before, are also collectively responsible to the Lok Sabha and individually responsible to the Prime Minister. And therefore, the fact that they have some responsibility to the Parliament makes them accountable to the Parliament to begin with, right? And that is why it is often said that there is a fusion between the executive and the legislature in India, and that is why separation of powers is not your textbooks, as they call it. It's not a watertight phenomena. Now let's look at the other overlaps. So when I look at the overlap between executive and judiciary, the fact that the president can perform certain judicial functions, and this is again done on the advice of the Council of Ministers, such as pardon, reprieve, respite, or remiss. We've done this in the Parliament, right? And for any person convicted by the Supreme Court of India is nothing but Article 72, which gives them certain judicial powers. Similarly, in case there is a dispute with respect to the retirement of ages of Supreme Court judges or even High Court judges for that matter, 124(2)(a) and 217(3). We'll cover this when we do judiciary, but this is not very important. कि वो retirement of seniority का issue होता है. First seniority, how long have you been a judge for? Second seniority, how long have you been a lawyer for? Third seniority is what is your age. अब इसमें कोई dispute है, then the president gets to decide for High Court as well as Supreme Court. This is again a judicial function to begin with. Apart from this, the judiciary also exercises executive functions under Article 227, where of course, the courts also have the powers of supervision of subordinate courts. So for example, when we say that high courts have the powers of contempt over all the lower courts in the state. For example, if somebody commits contempt against the district court of UP, then the high court at Allahabad has the powers to initiate contempt proceedings against that person. So those and then the high courts also have the powers to regulate the functioning of lower courts. In fact, in judicial services exams, these are state level exams, the exam is conducted by the executive, but the interview for state judges, for lower judges, the interview panel is of high court judges. इससे ज़्यादा क्या example दूँ? And then of course there are also administrative cases. There's transfer of cases from one court to the other under 228. Apart from that, there are also overlapping powers between the legislature and the judiciary, wherein, for example, when the parliament is performing, a contempt or a breach of privilege action, that's a parliamentary privilege. That's a judicial function. And similarly, when the courts have been given the powers to lay down their own proceedings, their own procedurals for how the court should run under 125, that means the court is regulating its own procedure. If the court is regulating its own procedure, and any regulation of procedure is a legislative function, so the legislature is overlapping into the judiciary. So that is something we must understand. That is something that we must be very very clear about. ठीक है, तो ये अब हमें समझ में आ गया. अब जो हमको ये समझ में आ गया, हमको ये भी क्लियर हो गया कि बॉस, if they are all three, then it also means that we have to make sure that they are keeping a check on one another, that they're keeping a check on one another. Okay, so let's quickly understand checks and balances. So because there is separation of powers, there is checks and balances. The parliament has the power to initiate impeachment against the president. 61, we've covered this. The parliament and the president together have the powers to remove the Supreme Court and the High Court's judges under 124 and 217. And of course, the judges are appointed by the president on the advice of the collegium, but the collegium advice can be returned. We'll do this in detail. And most importantly, the power of judicial review possessed by the courts under 32, 226 and 136 reflects checks and balances. The Supreme Court and the High Courts can review the validity of a law under 32, 226 and 136 is special leave petitions. That means any case from any lower court can directly be sent to the Supreme Court if there's a substantial question of law. That's all that 136 is. But anyways, and this gives birth to judicial review, and this judicial review gives birth to judicial activism. So I hope you're understanding judicial review and judicial activism have nothing to do with the functions of the judiciary. They're applications of checks and balances, and checks and balances are an application of separation of powers, which is why the UPSC asks you questions like these. Okay, very important for you to understand this. Now that we understand this, we then must understand what have the courts done. ऐसे answer में sprinkle करने के लिए one of the first cases was of course the Ram Javaya Kapoor case. The facts are not particularly important, but this was essentially you will see a lot of this will now have implications on tribunals, a lot of other things. So the Ram Javaya Kapoor case versus State of Punjab, the court had very clearly said that we do not have separation of powers, but directly in the constitution, but their functions and their responsibilities have been clearly laid out. In the reference Delhi Laws Act case, the Supreme Court said that the parliamentary system which is adopted by India entails the responsibility of the executive to the legislature as its essential feature. In Indira Gandhi versus Raj Narayan, this is the emergency case that we are referring to. The Supreme Court gave a reference to separation of powers and said that a rigid separation of powers is under American and Australian constitution. It does not apply here. And it also said separation of powers is basic structure of the constitution. So the schemes of the constitution even cannot be changed if you amend Article 368. This was in the context of 39th constitutional amendment of 1975, where she had basically tried to give immunity to the office of the Prime Minister, the Vice President, the President and the Lok Sabha Speaker from a judicial review. And in Golaknath versus State of Punjab, again, the court had remarked, this is the same Golaknath case that we've studied in fundamental rights, that all organs must function within the spheres allotted to them, and no authority which is created by the constitution is supreme, which is why the Supreme Court in this case had said the parliament cannot touch fundamental rights. This was of course overruled by Kesavananda Bharati a little later. Now, let's look at some further cases as well, and let's understand why separation of powers is a problem and how can we make it better. Okay, so see, when we look at the criticism, you must understand that, boss, in the first place, it is impossible to say this is where the work of legislature ends, executive begins, ends, and judiciary begins. Governance is dynamic by nature, and a smooth and stable government can only exist if they cooperate with each other. And therefore, when you try to isolate them, create boundaries around them, it will lead to friction, it will lead to non-cooperation, and it will often lead to a lack of participation. Okay, understood this? This is extremely important. Now, then if this concept as we know it is adopted in totality, if this concept as we know it is adopted in totality, then it will be very difficult to take certain actions, which means our parliament meets for less than 100 days a year. We discussed this. We've met for 67 days a year on average. So you will make a broad law and then you will give the technical details of the law to the executive. So there is no point of keeping it isolated. Similarly, if the legislature can't do this and you need the expertise of the government to get the best people to make those accurate, rules and all of those things, then you will never be able to get a good law. And if the parliament and the executive are incompetent, they're not available, they are not inclined to make a policy decision, in such a scenario, you have no other option but you have to make sure that the courts can make laws relating to the functioning of its proceedings and trying to fill the gaps of the legislature and the executive. Now, the world that we live in, the India that we live in today, the state works for the welfare. It is the responsibility of the government to work for the people, right? And therefore, complex issues can only be resolved if all of the three work together. And that is why this doctrine, in its rigid sense, will not help us with the objectives of the modern state. And that is why it is theoretically very impossible and practically is just a dream. The Montesquieu, who, when he thought of this, he wanted to protect the individuals. But this protection cannot happen by a strict separation of powers, especially right, in the context of parliamentary forms of government. Right to education, you made a law and the executive made right to education rules. How many more examples do I give you? Okay. Now, and therefore, what should our conclusion be? Our conclusion is very, very simple. It is the doctrine of separation of powers must be interpreted in a relative form. And what is this relative form? That in the era of LPG, it must be for a wider perspective. It should not be too restrained, but a group power in the spirit of cooperation and coordination. ये बहुत सोच समझ के मैं ये डायग्राम बनाया, आप ये यूज कर सकते हो. ये डायग्राम का क्या मतलब है? That the legislature, the executive, the legislature, the executive, and the judiciary will have their core powers. These core functions must remain intact, but they must all come together for administrative reasons, for the effective implementation of the law. And any powers which are overlapping incidentally must be done in the best interest. तो मैं ऐसा डायग्राम बनाएगा, तुमको बहुत अच्छा मार्क्स मिलेगा, तुम्हारे को नंबर आएगा, तुम एग्जाम क्लियर करेगा, मैं चैन की नींद सोएगा. ठीक है? Now honestly tell me, मतलब very honestly tell me, it took us what? 1 hour? That's it? And in 1 hour, your entire theory of separation of powers checks and balances, with an answer writing format, with all examples done. इसके ऊपर एग्जाम में कुछ आएगा? Will there, if there had to be a theory question, there'll be nothing more than what we have discussed so far. There'll be nothing more than what we have discussed so far. Yes. Now I'll give you a 5-minute break. You can write your doubts. DP, ask your doubt properly. Don't give me a headline. No, not really. These are very standard topics. They don't surprise you with these topics. Yes. COM on, Yash dropped me a message on this. COM on the floor of the House, access legislators. Yes. Thank you, Jayaprakash. I sent you a text. I'll have a look. Okay. Sure, Arzu. Totalitarianism. Totalitarianism basically means the ability of the government or the ability of anybody to primarily इसको कैसे समझाऊं मैं तुम्हें एक सिंपल लाइन में बोलूँ तो मतलब where people have absolute power or controlled power. ठीक है. Inter Vikram is between L, E and J. Intra is inside L, inside E and inside J. Thank you, Arzu. It is an honor to honestly be a teacher to all of you. Yes, Mehboob. Can a governor pardon a death sentence? No. Members of joint parliamentary committees are also appointed by Speaker of Lok Sabha. Yes. Okay. Now let's continue further. We have already covered ordinances with respect to the president. You may remember this. We've covered the data and we've covered all of this as well. We've covered the implications of it. How does it make a difference? What can we do to make it better? Now let's come to the fun part. This is what I really like. We've discussed about tribunals with respect to censorship and fundamental rights. We've discussed how they've abolished the censor board appellate tribunal. And I'm expecting a question on tribunal in the next year or so. There's been a question before also. So let's understand what is it that we're referring to. First, what is a tribunal? Tribunals are institutions which are established for discharging judicial or quasi-judicial duties. Now, they have been established under 323A and 323B of the Constitution. I'll come to those in just a bit. The primary objective here is to reduce the caseload of the judiciary or to bring in some kind of expertise like company law tribunal, income tax tribunal, and so on and so forth. Thank you. Thank you. Thank you, Manik, and thank you, Jay. Now, let's understand. See, when we look at a judicial or a quasi-judicial function, it comprises of two questions. One is a question of law, and the other is a question of fact. A question of fact is whether an incident or a specific event happened or not. And second, is that incident a violation of a law, a violation of a crime or not? Right? So these are the broad things that we have to understand. These are the broad perspectives that we have to look into. Okay? Clear on this? Now, the Supreme Court very categorically has ruled that tribunals, being quasi-judicial bodies, should have the same level of independence as from the executive as the judiciary. This includes, and this is where the problem lies, the selection of members, the composition of tribunals, and the terms and tenure of service. See, what happens with tribunals are that tribunals are basically specialized courts, but these specialized courts have both judicial members and executive members, bureaucratic members. Okay. Now the judiciary says that, boss, at the end of the day, you are a court, so we should get to decide how tribunals will function. Executive says, no, we will decide because we are setting it up. We've got our people here. So it is basically a question of separation of powers. Okay. So they will make a law, Supreme Court will give a judgment, and this entire drama will continue. Okay. Now that is why, to ensure that tribunals were independent from the executive, what the Supreme Court has recommended is that all administrative matters should be handled by the law ministry than the ministry associated with the subject area. Like for example, corporate law tribunal, the corporate law tribunal, the company law tribunal, this should not be under the Ministry of Corporate Affairs. This should be, the administrative matters should be under the law ministry. So same goes for Competition Appellate Tribunal, which now has been merged. Same goes for Income Tax Tribunal, and in fact the NGT also, right? Now the NGT, for example, should definitely come under the law ministry as per the Supreme Court recommendation. And this was in the news last year also, where they have also recommended for a National Tribunals Commission for the administration of the tribunals, where it has a certain degree of independence, it has a certain degree of impartiality, and all of that involved. Of course, none of this has been implemented, but this is the context to why we are discussing this. Now let's get into the technical details, and I'll give special focus on NGT also. First question is, why do you need tribunals? Understanding the pendency of courts and to reduce the workload of courts. We will do judicial pendency as a topic in judiciary, and you'll understand how 80% of our cases are actually pending in the lower courts, and of course 20% are in the higher courts. And the sheer number of cases are too extraordinarily high to even think of. And because courts are complex, they're procedural in nature, there are certain standard operating procedures that you have to follow, it automatically makes the decision making process a slightly longer one. And it is also very expertized, wherein you need to have the procedural tenacity of a lawyer, the procedural grip of a lawyer, to sort of let people work and get up to court. And that also becomes very expensive also. Apart from this, the judges are also generalists at the end of the day. But today we are evolving towards very complex laws. Like for example, in the budget, we've said that we will have, a central bank currency. We said that cryptocurrency incomes will be taxed. Very interestingly, cryptocurrency is still not legal. It does not mean that you can go to Big Bazaar and pay in Bitcoin. That's not the case yet. And the government has often made money from things which are illegal by taxing it. So that's not the case. The case is, when something like this happens, when you look at cyber law, sports law, intellectual property law, copyright law, you look at insider trading, you look at a lot of these modern notions of law, and our judges are not technically equipped for it. Even if our bureaucracy is not equipped for it, how do you expect our judges to be equipped for it? And the bureaucracy is the most talented pool of people in the country. And of course, tribunals were never a part of the original constitution. And in fact, now if you're able to relate it with the emergency, in 1976, because the court was being the court, and in 1973 had come up with basic structure in Kesananda. This was to essentially bring courts closer to the executive, and 323A and 323B were added as a part of the 42nd Constitutional Amendment of 1976. Then comes a very simple question. What is the difference between a court and a tribunal? What is the basic difference? Let's understand. See, a court of law is a part of a conventional legal system. Okay, a traditional or a conventional legal system. Whereas a tribunal is a specialized agency which is created by law and has judicial powers. Like how you guys have judicial powers under CRPC through a law, you've created a higher version of you, right? A higher version of an executive magistrate. Now you see, civil courts have judicial powers to try all suits of a civil nature, unless of course it is specifically mentioned that this case can't go to a civil court. Whereas tribunals are specialized. they have very specific set of jurisdictions, right? Now, in terms of the judges of ordinary courts of law, they are sort of independent from the executive. How long will you be a district judge, a civil court judge, all of that? It is independent of the executive. Whereas here, you, for example, of the administrative tribunal, are entirely in the hands of the government. The government appoints, the government removes, even if they're judicial members. It's the government actually appoints and the government who removes. The presiding officer of the court, the chief justice of the court, so to speak, is a person who is trained in law. Here, that's not the case necessarily. For example, we used to have the banking, finance, reconstruction tribunals. I have appeared in these tribunals quite a few number of times. The presiding officer or the chief justice is the wrong word, but the head of that court sometimes was a retired bureaucrat or a very, very senior bureaucrat. The bureaucrat was heading a tribunal. Even today also, if you go to these commissions, your consumer commissions, I sometimes have to go and appear at them. They're near the ITO. The judge I'm appearing before is a bureaucrat and sometimes happens to be an old student also. So it becomes a little awkward. I'm like, Your Honor. He's like, sir. Your Honor, sir, Your Honor. So it gets a little awkward at sometimes. But okay. So, yeah. So that is the case. And then, of course, like if, for example, if this person, I remember, I think last year or something, it was a consumer court, some matter, and then the person thankfully had a pleasant experience with polity and was happy with the marks that the person had gotten. So, he was nice enough. But had the polity paper not gone well for him, I don't know if I would have gotten the relief that we had, rightfully deserved. But anyway, now, so the judge of a court of law must always be impartial, right? Of course. But here you see the government might also be a party to it, and the presiding officer is also the government. The judiciary is never a part of the case, right? But here the presiding officer, the president of the tribunal is a member of the bureaucracy, and sometimes the case might be against the government. So there could be conflict of interest. Here you have your CRPC, you have your CPC, you got your procedural laws, Evidence Act, everything here. And that is why these procedural technicalities are not there for your tribunals. You can have your own procedures, simplified procedures, fastened procedures, and you are largely guided by the principles of natural justice. We've discussed these principles. You can't be forced to be a judge in your own case, and you have the right to a free and a fair trial, right? And the courts look at it from a completely objective point of view, right? Whereas tribunals also have a policy-infused decision-making. That while I understand that it may not be the right thing to do, but the policy is such that it fits into the larger tenets of the policy. That is why often, decisions of administrative tribunals get very subjective. A lot of times, some of you guys, after you clear the services, have issues with your postings, have issues with some issue of, you've been discriminated against, or your cadre has not been changed, or your cadre-based marriage is not being approved, or your cadre transfer is not happening, and all of those things. So you have to often go to the Central Administrative Tribunal and all of those things. Now, all of that depends on the larger cadre policy at the time. I can argue my heart out and say, but you have the fundamental right to freedom of work. Civil services rules say that you have the right to a cadre-based transfer. Then the administrative tribunal says, Mathur sahab, baat to sahi hai. But you see, this is all India service. And we don't want the shift of officers right now because it causes administrative difficulty. So while I understand, good question you have, great question. But your question has hurt me, Mathur sahab. But that's not going to happen. So sometimes, I often come back empty-handed on a lot of these inter-cadre issues that sometimes come to me for representation. Anyways, so this is exactly how your tribunal system works. You've got fundamentally two constitutional provisions around it. First is Article 323A. And then you have 323B. Now, 323A deals with administrative tribunals only. and 323B deals with everything else. Now, administrative tribunals can only be established by the parliament, and there's one at the center and one for each state. Sometimes you can have one for two states. So the one that we often go to is the Central Administrative Tribunal. Okay, your cases as All India Service Officers are often here at Central Administrative Tribunals. Okay, now 323B, they largely deal with everything else. So you've got Securities Appellate Tribunal, companies, got NGT, and they deal with the large ceiling of disputes. There's tax tribunals, you've got foreign exchange tribunals, import-export tribunals, industrial tribunals, land reform tribunals. Now you have foreigners tribunal also because of the CAA. Then you also have urban property tribunals. You can have elections to parliament and state legislative tribunals, but we've not implemented them. You have debt recovery tribunals and of course tenancy tribunals. Now these tribunals can be established by the parliament or the state legislature, because these are concurrent list subjects fundamentally to begin with. And in 2010, you don't need to know the judgment, the Supreme Court had basically clarified that these are not exclusive powers. You can add anything else which is in the concurrent list and make a tribunal out of it. And of course, there can be a hierarchy of tribunals: junior tribunal, senior tribunal, appellate tribunal. Now, depending on the hierarchy, some tribunal cases will go to the High Court, some will go directly to the Supreme Court, and no tribunal case goes on appeal to a district court, right? Some lower tribunals will go on High Court, some will go to the Supreme Court. It depends on the hierarchy. That is too technical for you. You don't have to worry about it too much actually. Okay, so this is how it largely functions. Now, what are the basic advantages and disadvantages of tribunals? See, tribunals offer a sense of flexibility. Our flexibility nahi ki jeans or t-shirt mein ja rahe hain. It is flexibility in terms of procedure. Okay, and it is also supposed to be relatively cheap. Supposed to be, because it's faster, cases get listed faster, you get immediate relief, and procedure is very simple, and it gives relief to the existing overburdened judicial system. But at the end of the day, because you're not bound by procedure, you're not bound by law, right? And though there is a uniform code of procedure for civil and criminal cases, every administrative tribunal has its own process. जो वहाँ चलेगा वो यहाँ नहीं चलेगा, जो यहाँ चलेगा वो वहाँ नहीं चलेगा, उसके लिए कुछ नहीं कर सकते. And a lot of times when they're headed by bureaucrats who are not trained in judicial proceedings. See, how you run a court, how you conduct the proceedings of a court versus how you conduct the proceedings of a departmental inquiry, they're two very different things. है ना, माना है कि आप लोग महान हो, बट थोड़ा हम लोग को भी आता है, ठीक है? So that's something we must understand. Okay, now that we get this part right, let's move to the primary issues with tribunals. Now, there are a lot of data sets that I've given you. Let's understand. The first issue is with the independence of tribunal. See, any involvement of the central government in the administrative activities of tribunals, मतलब कितना छुट्टी ले सकते हैं, किसको अपॉइंट करेंगे, किसको नहीं करेंगे, will obviously affect the independence of it. And for this, the Parliamentary Standing Committee on a Departmental Parliamentary Standing Committee on Personnel, Public Grievances, Law and Justice in 2015 had very clearly recommended the creation of an independent body called the National Tribunals Commission. ये 2015 का है. हर साल हिंदू में कोई एक आर्टिकल लिखता है और एस्पिरेंट्स का ऐसे छाती, अरे वाह एनटीटी एनटीसी ऐसा कुछ नहीं है. 2015 से चल रहा है. So we have to be calm, we have to be composed about it, and basically setting up a body for the regulation and the administration of tribunals. Okay, understood? ठीक है? Now, let's look at the pendency of cases. Now you see, even some of the tribunals who are supposed to largely solve the problems of cases are still facing a large backlog. Like, for example, I'll give you the industrial and labor courts, which were set up by the central government for these cases. as of March 15th, 2021, had 7,312 pending cases. ये डेटा मैं 2022 के लिए मार्च के बाद अपडेट कर दूंगा. And the Armed Forces Tribunal, which was basically set up for disputes within the armed forces, had 18,000 pending cases. Okay, 18,000. And the Income Tax Appellate Tribunal, जहाँ सबसे ज़्यादा लोग जाते हैं, ठीक है, had 92,000 pending cases. 92,000 pending cases. ठीक है, आप समझ रहे हो यहाँ पे क्या इशू है. ठीक है. Now, why does this happen? Because आपने ट्राइब्यूनल तो बना दिया, but you don't have the right number of resources, you don't have the right number of judges, the staff. Like for example, your National Company Law Tribunal was supposed to have 63 judges, only has 30 judges or 30 members. We don't even call them judges because हमको ego hurt होता है, but we call them as members, right? Now these vacancies are concerning because as of 31st May 2021, because we've not had the 2022 data yet, there were 13,000 insolvency petitions which were pending, which is why in the budget they've also looked for a faster resolution process to enhance this ecosystem. And the Standing Committee on Public Grievances in 2015 had also said that several tribunals such as cyber and armed forces have vacancies which have not been fulfilled and therefore are being dysfunctional in nature, so to speak. Okay, so those are the larger issues that have been going on. Now let me run you through the judicial history of tribunals. ठीक है, judicial history थोड़ा सा basic बताऊंगा, आप बस सीख लो क्या होता है, you will not have a problem. ठीक है, I'll zoom in, don't worry, some of you may not be able to see this. The story starts before independence only. Actually the story starts before independence, okay, in 1941, where India's first tribunal was set up under the British rule called the Income Tax Tribunal. Okay, then in 1969, the first Administrative Reforms Commission has suggested that we should have a Civil Services Tribunal. बात तो सही कही. Then in 1974, the sixth Administrative Reforms Commission suggested that we should have some special tribunals to reduce the workload of high courts. Then in 1976, based on these recommendations and another committee called Swaran Singh Committee, which also gave recommendations for certain duties and directive principles, we added the 42nd Constitutional Amendment, which added 323A and 323B. And that is how your administrative tribunals, your all India tribunals for labor and industry, land revenue tribunals, they were all set up, and they were all supposed to be under the scrutiny of the Supreme Court, because at the end of the day they're performing some legal functions. और 80s के दशक में आते आते हमारे पास एडमिनिस्ट्रेटिव ट्राइब्यूनल, सिक्योरिटीज ट्राइब्यूनल, फिल्म ट्राइब्यूनल्स, इलेक्ट्रिसिटी ट्राइब्यूनल्स धीरे धीरे बनने लग गए. ठीक है, अब सब बढ़िया चल रहा था. नाउ थिंग्स स्टार्टेड गेटिंग अ लिटिल कॉम्प्लेक्स. नाउ कम्स द जजमेंट अमेंडमेंट इशू. ठीक है, नाउ लेट्स लुक एट दिस. ठीक है, okay. The case in 1986, SP Sampath versus Union of India challenged the constitutionality of some tribunal. उसमें बोला सुप्रीम कोर्ट ने कि Parliament can create tribunals which are parallel to high courts and cases can go directly to the Supreme Court, but these appointments must be in consultation with the Chief Justice of India and the Supreme Court or other Supreme Court or High Court judges. ठीक है, first move by the judiciary. 1997, L. Chandra Kumar versus Union of India. This is also where judicial review is recognized as basic structure. In this case, the Supreme Court said all of these High Court equivalent tribunals must be treated like the High Courts and their original jurisdiction. मतलब cases that can directly be filed to these tribunals must be supervised by the High Court. यहाँ तक पहले हम सुप्रीम कोर्ट की बात कर रहे थे, ठीक है. एंड whenever possible there should be a higher preference and powers to judicial members because judicial function, and you should set up an independent agency in the times to come. Until then you can keep it under the Ministry of Law and Justice. फिर 10 साल 20 साल किसका किच नहीं हुआ, ठीक है, 10 साल. Then in R. Gandhi versus Union of India, R. Gandhi राहुल गांधी नहीं है, ठीक है. In this, the court said the parliament and please understand, the parliament can make tribunals which are alternates to high courts on subjects which are in the union list. Judicial members will be given more powers than technical members, and if your aim is to dispose of cases faster, then you don't need technical members. Broad हमको समझ में आ गया है, judicial members ही कर लेंगे. And if you have to appoint technical members, they should be secretary level officers with technical knowledge. अब तो कोर्ट ये भी बता रहा है कि बेटा किसको बिठाना और किसको नहीं बिठाना, ठीक है. Now in 2014, Madras Bar Association versus Union of India, in this they said that boss, members of the Indian Corporate Law Service and the Indian Law Service, they cannot be considered as judicial members but only as technical members. तो गवर्नमेंट ने कहा ठीक है, हमारे पास कॉर्पोरेट लॉ सर्विस बना है ना, हमने इनको बिठा लें. जो सुप्रीम कोर्ट ने कहा बक तू सिविल सर्विस में अपॉइंट किया ना इनको, तो इनको कहां से बिठा देगा, नहीं हो पाएगा, ठीक है. एंड मिनिस्ट्री ऑफ लॉ एंड जस्टिस, Ministry of Law and Justice to provide some form of an administrative support, and there should be a help of the parent department कि corporate affairs के लिए corporate affairs थोड़ा सा technical support दे देगा. अब गवर्नमेंट ने कहा अब मेरा पारी है, मैं संपत का, चंद्रा का, गांधी का, बार का, सबका बदला लेगा. So in 2017, as a part of the budget itself, they, through the Finance Act, and this was questioned, that how can you make a provision to tribunals as a part of the budget? You are trying to bypass the Rajya Sabha because this could have been a money bill, right? And so they started merging tribunals. 26 ट्राइब्यूनल को काट के 19 ट्राइब्यूनल कर दिया और कहा कि सेंट्रल गवर्नमेंट के पास पावर्स होंगी टू मेक रूल्स ऑफ these tribunals. This was then challenged in the court in 2019 in the Roger Matthews versus South Indian Bank case and others. The Supreme Court said judicial function सिर्फ judicial members करेंगे, judgment judicial वाले ही लोग देंगे. Executive will have no powers at all to remove judges. There will always be a uniform age of retirement. ये नहीं कि जज को 10 दिन पहले छोड़ दिया या 20 दिन पहले छोड़ दिया, ये नहीं कर सकते. लेट मी फर्दर मैक्सिमाइज दिस अ बिट, ठीक है. अरे थोड़ा ज्यादा ही हो गया. ओके. And you cannot have short tenures, and you need to have a judicial assessment कि भाई आपने जो ये मर्जर करा है, इस मर्जर से एक्चुअली बेनिफिट हो भी रहा है कि नहीं. Then in 2020, again in the Madras Bar Association case went on appeal to a higher bench. Then the Supreme Court said, भैया National Tribunals Commission बनाओ, otherwise we will keep fighting, and there should be a 5-year tenure instead of a 4-year tenure, और सीधा 67 years का आप रिटायरमेंट लेके आओ, ठीक है. गवर्नमेंट ने कहा इससे कैसे. अब मैं 2021 में ट्राइब्यूनल्स रिफॉर्म एक्ट ही ले आए लास्ट ईयर. उसकी वजह से जो बचे कुछ 19 थे उसमें से आधे और हटा दिए, और मिनिमम 50 एज कर दिया कि इतना का होना ही चाहिए टू बिकम अ ट्राइब्यूनल मेंबर, एंड टेन्योर विल बी 4 years। लड़ाई कर रहे हैं। And then in 2021, the Madras Bar Association case, they struck down the 4-year rule and they struck down the 50 years of retirement। देखा, वो याद है शंकरी प्रसाद, सज्जन सिंह, गोलकनाथ, ये वो सेम इशू चलता है इधर, सेम इशू। ठीक है, क्लियर। सो दिस इज द जर्नी एंड दिस इज द स्टोरी ऑफ ट्राइब्यूनल्स इन इंडिया। ओके, नाउ अब ये जो रैशनलाइजेशन की बात थी वो क्या थी? वो ये थी कि बॉस, वी विल डिसॉल्व सर्टेन एग्जिस्टिंग बॉडीज जैसे सिनेमा ट्राइब्यूनल, कॉपीराइट, कस्टम्स, पेटेंट्स, एयरपोर्ट्स, प्लांट वैरायटीज, ज्योग्राफिकल इंडिकेटर्स, और हम 50 years मिनिमम रखेंगे। 4 साल का चेयरपर्सन का एज होना चाहिए, 4 साल का टेन्योर होगा, चेयरपर्सन 70 साल, बाकी सब बुढ़ाऊ 67। ठीक है, नाउ द ब्रॉडर इश्यूज वाज दैट इट इंक्रीजेस द जुडिशियल बर्डन। इट इज ए डायरेक्ट वायलेशन ऑफ द सुप्रीम कोर्ट ऑर्डर, जिसमें उन्होंने कहा था कि भैया यू शुड कीप 50 years and 5 years as your tenure। ठीक है, अब क्या क्या डेवलपमेंट्स हुआ ये मैंने यहाँ पे लिख दिया है, आप इसको रिवाइज कर सकते हैं, आप इसको पढ़ सकते हैं, विच विल बी ईजियर फॉर यू टू डू देम। ठीक है, अब ये वाला केस था, इस केस में 3 इश्यूज थे जो हम रॉजर मैथ्यू की बात कर रहे हैं कि ये आपने किया कैसे, हाउ वाज इट पास्ड एज अ मनी बिल। ये टेक्निकल डिटेल्स पूछते नहीं है लेकिन मैंने आपको दे दिया है। And of course, this also had an issue with respect to can a money bill, can the Supreme Court review a decision of the Speaker with respect to a money bill? हम ऑलरेडी डिस्कस कर चुके हैं, हाँ हो सकता है। मैंने एक एक का आंसर yes no करके दे दिया है, आपको कोई प्रॉब्लम नहीं होगी। And then there are some solutions that were given by the court that the tribunal should be financially independent, there should be a financial impact assessment in terms of how much money is needed, tribunal members should not be given the status of a Supreme Court or a High Court judge, and then the legislature should consult the Law Commission and sort of look at the provision for statutory appeals, and there should be a direct appeal to the division bench of the High Court. This is directly from page number 124 of the Supreme Court judgment। इतना बढ़िया मान लिखेगा ना तुम आंसर में तो कितना अच्छा लगेगा, समझ में आ रहा है तुमको? And then after assessing case loads, then the court can decide on a case-to-case basis as to why this has to be done। And then this is the National Tribunals Commission जो न्यूज़ में बहुत सारा था। ठीक है, the idea was first mooted in the Chandra Kumar case। It should be established by a constitutional amendment and they should have a uniform procedure, and therefore you could create separate judicial and administrative sort of functions। ये हिंदू के आर्टिकल से लिया है मैंने, that a corporatized structure in the form of a board, a CEO will be able to set up services so that companies also start using these tribunals better। They should have performance evaluations, they should have a independent recruitment body so that everybody can get a job, and also you get the best of people here। And the administration roles should be to provide training, support services, and for that you should be able to hire directly some kind of an administrative staff। ठीक है, तो ये आपका ट्राइब्यूनल्स कमीशन हो गया। और इसके अब एक सवाल उठता है कि बॉस, सुप्रीम कोर्ट और हाई कोर्ट के पास तो सुओ मोटो पावर हो सकती है कि अपने आप बिना केस फाइल करे केस ले लिया है। ठीक है, ऑफ कोर्स दे आर ठीक है, बट शुड ट्राइब्यूनल्स आल्सो हैव सुओ मोटो पावर्स? एंड दिस वाज एन इशू बिकॉज ऑफ 2020 where जब गैस लीक का इशू हुआ था, और ये एनजीटी सबसे ज्यादा करता है। सो देयर वाज अ गैस लीक बाय द एलजी पॉलीमर्स कंपनी, किसी ने पिटीशन नहीं फाइल किया था, NGT self took the case। सुओ मोटो means self taking the case। ठीक है, एंड 50 करोड़ का फाइन भी लगा दिया था। In October 2018, NGT had passed an order on the basis of a news report, and 5 करोड़ का म्यूनिसिपल कॉर्पोरेशन पे फाइन लगा दिया था। Similarly, in March 2021, NGT had passed an order जहाँ पे वो based on a letter which was written to the chairman of the NGT कि आपका quarries और residential areas का difference 500 से 200 मीटर होना चाहिए, ठीक है. And all of these orders were passed by suo motu jurisdictions. Now the question is, can you do this or not? And therefore, statutory bodies, tribunals are basically statutory bodies. They have to be restricted to their statutory jurisdiction, and constitutional court नहीं है सुप्रीम कोर्ट और हाई कोर्ट की जैसे कि बेटा ट्राइब्यूनल हो, नाचो नहीं जाता. This would then, of course, violate constitutional principles of separation of powers and checks and balances. अब ये क्यों करते हैं? See, the National Green Tribunal Act, under which NGT was established, it does not say that the tribunal has suo motu powers. Similarly, Karnataka Land Reforms Act, वहाँ पे limited powers दे रखी है. Then the Debt Recovery Tribunal says it does not have any suo motu powers, and they're not mentioned also expressively in the Recovery of Debts Act of 1993. And therefore you cannot interfere from general powers to regulate their own procedures. कहीं लिखा नहीं है directly आपकी powers होनी चाहिए या नहीं, ठीक है. Now then comes NGT. NGT का स्पेसिफिक क्या इश्यूज थे, क्या नहीं थे, वी विल कवर. आप इसको एक बार पढ़ भी सकते हैं. द सेम इश्यूज देन गेट अप्लाइड टू NGT. आई हैव गिवन यू सम केसेस आल्सो ऑफ NGT एंड suo motu पावर्स, ठीक है. एंड देन ऑफ कोर्स वी विल स्टडी जुडिशियल रिव्यू एंड जुडिशियल एक्टिविज्म टुमारो एंड मूव विद द रेस्ट ऑफ द टॉपिक्स. इट इज द करंट ऑर्डर 2021, निशांत, ठीक है. अंडरस्टूड? Okay, we'll discuss NGT, judicial activism, and a lot of those things now tomorrow. Thank you.